and the counsel representing the Deputy President. The charges were read, and the Deputy President pleaded not guilty to the 11 charges that were leveled against him and forwarded to the Senate for consideration by the National Assembly. And so this afternoon, the Speaker of the Senate will rule on whether to allow the objection that was raised by the Deputy President through his counsel that opposed to the inclusion of Siaya County Governor James Agri Orengo to represent the National Assembly. And so the defense the defense wants the senior counsel to recuse himself from the proceedings. This afternoon, the Speaker will give a ruling after the National Assembly has given its response. If you're just joining us, in a few moments, the Senate will resume its sittings where it is hearing the impeachment case against Deputy President Rigathi Gachagua. Good afternoon. If you're just joining us, this live proceedings from the Senate chambers, and the business of the Senate will begin anytime from now. And before that, we'll recap the charges that were leveled against the Deputy President, among them gross violation of Articles 10, Article 2A, B and C, Article 27, 4, 73, 1A, and 2B, among others. The other ground is gross violation of Articles 147, Subarticle 1, and Article 152, Sub-Article 1 of the Constitution, that His Excellency Rigathi Gachagua has on several occasions throughout the last 2 years made public statements contradicting the President on critical matters of governance and the exercise of the President's functions as a symbol of national unity. Ground 3, gross violation of Article 6, Sub-Article 2, Article 10, Sub-Article 2A, Article 174, Article 181, Sub-Article 1, Article 189, Sub-Article 1 of the 4th Schedule to the Constitution, undermining devolution. That His Excellency Rigathi Gachagua publicly disparaged the leadership of the Nairobi City County Government and its decisions. Moreover, His Excellency Rigathi Gachagua has interfered with the proper discharge of county government's constitutional functions regarding alcohol control and regulation. His Excellency Rigathi Gachagua's insightful and demeaning public statements and conduct are impeachable offenses to the extent that they undermine devolution, they undercut the functional and institutional integrity of county governments, they unjustifiably vilify and ridicule the leadership of county governments, especially the Nairobi City County Government. Consequently, His Excellency Rigathi Gachagua has grossly violated Articles 6, Sub-Article 2, Article 10, Sub-Article 2A, Article 174, Article 186, Sub-Article 1, and Article 189, Sub-Article 1 of the Constitution, as read with the 4th Schedule to the Constitution. Ground 4, gross violation of Article 160, Sub-Article 1 of the Constitution, and this one concerns the undermining of the institutional and decisional independence of judges. That the Deputy President made a scathing public attack against the Honorable Lady Justice Esther Maina, Judge of the High Court of Kenya, and falsely threatened to file a petition for the removal of the said judge in gross violation of Article 160, Sub-Article 5 of the Constitution. The judge had presided over a case in which His Excellency Rigathi Gachagua was a party and had, in the lawful performance of a judicial function, ordered His Excellency Rigathi Gachagua to forfeit to the state the sum of 200 million shillings, which she had found to be proceeds of corruption and money laundering. That His Excellency Rigathi Gachagua's public attacks against the judge are impeachable offenses to the extent that they undermine the functional and decisional independence of judges. Charge 5, gross violation of Article 3, Sub-Article 1, and Article 148, Sub-Article 5A of the Constitution, which talks about breach of the oath of office and allegiance. Part B of that ground is serious reasons to believe that the 62 of the National Cohesion and Integration Act that His Excellency Rigathi Gachagua was persistent, inflammatory, reckless, insightful public utterances over the last 2 years, the details of which are set out in grounds 1, 2, 3, and 4, establish serious reasons to believe that he has committed crimes under Section 13(1) and Section 62 of the National Cohesion and Integration Act. Ground 7, reasons, serious reasons to believe that His Excellency Rigathi Gachagua has committed crimes under sections 45, subsection 1, section 46, section 47A, part 3, and section 48, subsection 1 of the Anti-Corruption and Economic Crimes Act, and section 2, 3, 4, and 7 of the Proceeds of Crime and Anti-Money Laundering Act. But for the past 2 years, His Excellency Rigathi Gachagua has inexplicably amassed a humongous property portfolio estimated at 5.2 billion shillings, primarily from proceeds of corruption and money laundering. The value of the property and wealth that His Excellency Rigathi Gachagua has acquired over the last 2 years is incompatible with his legitimate income, that is 12 million shillings per annum or thereabouts. That His Excellency Rigathi Gachagua has acquired the above-mentioned property and wealth using his 2 sons, Kevin Rigathi Gachagua and Keith Ikinu Rigathi, and other close family members and associates as proxies. That His Excellency Rigathi Gachagua and his proxies, especially the 2 sons, have used the companies listed to massively launder money, conceal proceeds of crime, corruption, and benefit from influence peddling. Among the companies listed are Spirit Way Limited, Fortis Vase Group Limited, Grand Bypass Apartments Limited, Kuruwitu Properties Limited, the Anansi Collective, Calvary Creed International Limited. These are some of the companies that have been listed by the National Assembly as those that have been used in violation of the provisions of the Constitution. Ground 8, serious reasons to believe that His Excellency Rigathi Gachagua has committed crimes under Section 132 of the Penal Code and Section 29 of the Leadership and Integrity Act. The Sergeant at Arms is announcing the arrival of the Speaker of the Senate, signaling the commencement of the afternoon sitting where the Senate is trying the Deputy President. Now I will hand you over for the live broadcast. My name is Edward Kabasa. Enjoy your viewing.
Na tuombe. Ewe Mwenyezi Mungu, tutakusihi tutazame kwa neema nyingi na baraka sisi watumishi wako ambao umeridhika kutuita kwa nyadhifa za uongozi katika jamhuri hii yetu. Tutakuomba utuajalie tuyatende na kufikiria mambo yote atakayofikishwa mbele yetu kwa njia ya haki na uaminifu, ili kustawisha amani, ufanisi na heri ya nchi yetu na wale ambao haja zao umezikabidhi mikononi mwetu. Amen. Clerk, do we have quorum? And you proceed to call the first order.
Order number 1, communication from the chair.
Now, honorable senators, this morning, at the commencement of the hearing for the removal from office by impeachment of His Excellency Rigathi Gachagua, the Deputy President of the Republic of Kenya, legal counsel for the Deputy President, Mr. Ndego Njiru, learned counsel, raised a preliminary objection on the legal representation for the National Assembly. Learned counsel opposed the appearance of Honorable James Orengo, senior counsel, who is the serving governor of Siaya County and therefore a state officer. Learned counsel submitted that the Honorable James Orengo is a full-time serving state officer, as per Article 260 of the Constitution, as read together with Section 26, subsection 2 of the Leadership and Integrity Act, which bars a full-time state officer from engaging in any other gainful employment. Counsel further submitted that it would be prejudicial to the Deputy President if the Senate allowed Honorable James Orengo to represent the National Assembly in these proceedings. Counsel drew the attention of the Senate to the precedent set in the matter of the proposed impeachment of the Deputy Governor of Kisii County, Honorable Richard Monda, in which a decision was taken to bar Honorable Sylvanus Osoro, Majority Whip of the National Assembly and Member of Assembly for South Mugirango in Kisii County, from appearing as counsel for the Kisii County Assembly. In his submission, counsel cited Article 77 of the Constitution and Section 26 of the Leadership and Integrity Act, as well as the decision of the High Court in Office of the Director of Public Prosecutions versus Orengo, Manduku, and two others, interested parties, Constitutional Petition 204 of 2019-2021, KHC 456 KLR 27 April of 2021, where Honorable Justice Ogola found and ruled that the continued representation of the first interested party, Mr. Manduku, by the respondent, Honorable James Orengo, as then was, or any other state officer is against the spirit of Chapter 6 of the Constitution for failing to conform to the mandatory provisions of the Leadership and Integrity Act. The judge ruled that in that case, there was an inescapable conclusion of conflict of interests in Senator Orengo representing the petitioner, highlighted by the fact that the interested party, Mr. Manduku, the managing director of KPA, may at one time be summoned to appear before a committee of the Senate to answer to some of the matters that the petitioner was being investigated on. In response, Mr. Eric Gumbo, learned counsel for the National Assembly, submitted that Article 77 of the Constitution is the primary law that restricts activities of state officers and a state officer from engaging in any other gainful employment. Counsel further relied on Section 26 of the Leadership and Integrity Act, which he submitted, has defined gainful employment, and in this matter, no evidence had been laid that the Honorable James Orengo was participating in gainful employment. Counsel referred the Senate to the decision of the High Court in Busia Election Petition number 3 of 2013, where the court interpreted Article 77 of the Constitution and Section 26 of the Leadership and Integrity Act 2012. Counsel also cited the decision of the court in the Mwilu case, which defined conflict as where one is confronted by two different interests, where one is competing with the other. Learned counsel for the National Assembly submitted further that no prejudice has been demonstrated that would arise or be occasioned to the Deputy President by the participation of Honorable James Orengo in these proceedings. Learned counsel for the National Assembly sought to distinguish the decision by Honorable Justice Ogola in the Office of the Director of Public Prosecution versus Orengo on the basis that this case turned on the fact that Honorable James Orengo was at that time a sitting senator before whom the matters in respect of which his client was charged could potentially come for adjudication in the Senate, and that no possibility exists into the current matter with Honorable James Orengo as the governor of Siaya County. In his rejoinder, Mr. Njiru, learned counsel, submitted that Honorable Orengo is the serving governor of Siaya County and therefore a full-time state officer, and by that fact alone is a violation of Article 77 of the Constitution. Further, Mr. Njiru submitted that prejudice is not one of the applicable tests under Article 77 and Section 26 of the Leadership and Integrity Act, but that the only applicable test is whether or not Honorable Orengo is engaged in gainful employment. He argued that the National Assembly had not proved that Senator Orengo was providing pro bono services in this matter. Honorable Senators, Article 77(1) of the Constitution provides that a full-time state officer shall not participate in any other gainful employment. Further, Section 26 of the Leadership and Integrity Act provides that a full-time state officer shall not participate in any other gainful employment, while Section 26(2) defines gainful employment as work that a person can pursue and perform for money or other form of compensation or remuneration which is inherently incompatible with the responsibility of the state office or which results in the impairment of the judgment of the state officer in the execution of the function of the state office or results in conflict of interest in terms of Section 16. Having considered the matter, it is important to state that a state officer must inspire confidence. However, it is trite law that he who asserts must prove. In this regard, I wish to observe that the learned counsel for the Deputy President did not adduce evidence to prove indeed and demonstrate that the allegation of gainful employment. In fact, it is somewhat surprising that counsel attempted to shift the onus of proving gainful employment to the National Assembly. That argument is untenable. As to the ruling of the Senate, that barred Honorable Osoro from appearing for the County Assembly of Kisii in the impeachment proceeding of the Deputy Governor of Kisii County Government, it is clear that what was objectionable was that Honorable Osoro was not only a member of Parliament for a constituency in the same county whose Deputy Governor's impeachment was an issue, but also a high-ranking member of the leadership of the National Assembly, and by extension of the same Parliament before which the impeachment was being undertaken. It was ruled that in these circumstances, it was clear that in the minds of the public, the fine distinctions of the bicameral Parliament would be lost, and their confidence in the impeachment process would entirely be undermined. In the same breath, as rightfully contended by counsel for the Deputy President, it is true that in both Article 77 of the Constitution and Section 26 of the Leadership and Integrity Act, no test of prejudice is expressly provided for. It therefore follows that both the contention of the counsel for the Deputy President that his side will be prejudiced by the appearance of Senior Counsel James Orengo and the rebuttal by the National Assembly that no prejudice will be occasions are moot. Honorable Senators, ladies and gentlemen, having analyzed the preliminary objection raised and for the reason I have given, the preliminary by Senior Counsel James Orengo is hereby dismissed. We will now hear the response on the second objection raised by the counsel for the Deputy President. Counsel, you have 5 minutes to do that.
Thank you very much, Mr. Speaker, sir. I'll endeavor to respond to the preliminary objection within the time allowed to us. Mr. Speaker, sir, the objection was premised on Rule 20 governing the proceedings that are currently before this House. The rule reads that in presenting its evidence, the Assembly shall not introduce any new evidence that was not a part of the allegations against the President by the National Assembly as forwarded by the Speaker to the National Assembly to the Speaker of the Senate. Mr. Speaker, sir, the context of this rule is important. A true reading of this rule would indicate or would mean that every material that was available before the National Assembly while deliberating the motion that was before it is what is contemplated to have been sent to the Speaker of the Senate. The question, therefore, that we'll be asking ourselves this afternoon is whether there's any new evidence that has been adduced by the National Assembly. Our answer to that, Mr. Speaker, sir, is an emphatic no. And why do we say no? We say no for the first reason that the reference to the letter forwarding the material that came from the National Assembly contained, amongst other items, paragraph 21, which spoke to a report of a public participation that was conducted by the National Assembly. Mr. Speaker, sir, that report was tabled on the floor of the House, was adopted by the House. Deliberations in relation to that report were made. Not a single objection arose. It certainly follows, therefore, that that material from public participation became a necessary part of the material that was considered before the National Assembly. To give it context, Mr. Speaker, sir, in addition to the material that was presented by the mover of the motion to the National Assembly, the honorable members of the National Assembly had their deliberations, which also captured in the Hansard. In that Hansard, material was introduced by way of questions, by way of contribution from the floor of the House. That material, too, forms part of the evidence of the proceedings before the National Assembly. It therefore is our submission that just in the same manner in which the Hansard from the National Assembly forms part of the report that was presented before you, the report on the public participation too is an important component of that report. There must have been a reason why that public participation was conducted. In our humble submission, Mr. Speaker, sir, the appropriate test that one would want to apply on whether or not to allow that material to be before this honorable House is the all-celebrated test of relevance. Mr. Speaker, sir, it should not be lost that sitting as this House is sitting this afternoon, it is a quasi-judicial proceeding. It is a proceeding that is also inquisitorial. And so therefore, what is important is that the material that is presented by way of public participation or by any other way is relevant to help the House determine the truth or otherwise of the issues that have been raised for the consideration of this House. How then, Mr. Speaker, sir, do we get to answer that question? Mr. Speaker, sir, I've had a look at the specific document that my learned friend, Mr. Njiru, objected to. And Mr. Speaker, sir, it is an affidavit by one Mr. Peterson Njomo Mushira. Mr. Speaker, sir, Mr. Njomo Mushira says that he followed the proceedings before the National Assembly. He says in particular at his paragraph 4 that he has also had occasion to look at the response filed by His Excellency, the Deputy President of the Republic of Kenya, at part 1.1 of his response. And he says that he has personal knowledge of the items that were contained or that would give clarity to part of the assertions in response by His Excellency, the Deputy President. Mr. Speaker, sir, for context, that part 1.1 is contained in volume 6 of one of the volumes that were presented before you. It is the volume speaking to the response by His Excellency, the Deputy President. At part 1.1, Mr. Speaker, sir, it speaks about a hotel called the Olive Garden Hotel. In particular, at part 1.1.4, His Excellency, the Deputy President, says, in accordance with his instructions, the hotel was sold by executors to a third party. Mr. Peterson Njomo Mushira, on the other hand, says, I have information that could
Counsel
help.
for the National Assembly, 1 minute.
Thank you very much, Mr. Speaker. Mr. Peterson Njomo, Mr. Speaker, sir, then says that he has information which indicates that number one is a shareholder to the company which bought that hotel, and that according to him, Mr. Speaker, sir, he got into a secret transaction with His Excellency, the Deputy President, to buy that hotel. Mr. Speaker, sir, it is our submission that that is material that is relevant for purposes of consideration of the matter that is before this House. Mr. Speaker, sir, I urge that that objection be dismissed. I'm most obliged.
Thank you. Honorable Senators, ladies and gentlemen, we need not take a break to allow me prepare my ruling. Just give me a minute. I put my thoughts together so that we make progress.
Mr. Speaker, sir, with your kind permission, I was just seeking your guidance whether I need to do a rejoinder because I'm the one who had moved the assembly in respect to the...
Very well. You may go ahead as I put my thoughts together.
Thank you very kindly, Mr. Speaker, sir. In response to what my learned friend has raised, the application or the objection had nothing to do with the public participation as cited. We simply raised an objection that goes to the roots of the ability to enjoy proceedings that will appear fair to all parties. My objection was premised on the non-derogable right to a fair hearing. Counsel has addressed you that the deponent of that affidavit, one Jomo, was responding to the Deputy President's response. There's nothing that can be far from the truth. And this is a witness who is being brought to panel beat or to attempt to panel beat the case for the National Assembly. The question and the test, Mr. Speaker, sir, is, shall we suffer prejudice? Shall our rights be deemed to have been held? And that is the non-derogable right to a fair hearing. This is not a witness who was before the National Assembly. Where is the source of this information in the document that was submitted to this House by the Speaker of the National Assembly? Where does it sit? Who sits to suffer prejudice if the same is admitted? Is it a state organ or an individual in the name of the Deputy President of the Republic of Kenya? We urge you to uphold our ruling and justice be seen to be done, even to the people following these proceedings. I am most obliged.
Now, Honorable Senators, the second preliminary objection raised by the Counsel for the Deputy President was that the following documents which were submitted by the National Assembly on Monday, the 14th of October 2024, were not part of the bundle of documents of the National Assembly that was served on the Deputy President on Wednesday, the 9th of October 2024. These are an affidavit signed by Mr. Peterson Jomo Mushira, and B, the document of the National Assembly marked as Volume 8A, responses from various government agencies. Counsel for the Deputy President stated that these documents prejudiced the Deputy President's case and amounted to a trial by ambush by the National Assembly. Counsel urged the Senate to bar the introduction of these two documents as they constitute new evidence in terms of Rule 20 of Part 1 of the second schedule to the Senate Standing Orders. Counsel for the National Assembly opposed the preliminary objection raised by the Counsel for the Deputy President. Honorable Senators, ladies and gentlemen, Rule 20 of Part 1 of the second schedule to the Senate Standing Orders provides, and I quote, "In presenting its evidence, the Assembly shall not introduce any new evidence that was not part of the allegations against the President by the National Assembly, as forwarded by the Speaker of the National Assembly to the Speaker of the Senate." As I indicated in my earlier communication, by a letter dated 8th of October 2024, I received a bundle of documents and records of proceedings in the National Assembly in this matter. Thereafter, on the 9th of October 2024, pursuant to Rule 6 and 7 of Part 1 of the second schedule to the Senate Standing Orders, the Office of the Clerk of the Senate sent invitations to appear to both parties. The parties were required, amongst other things, to specify any other evidence to be relied on this matter. I will repeat that. The parties were required, amongst other things, to specify any other evidence to be relied on in this matter. In response to this invitation, on Monday, 14th of October 2024, the National Assembly filed further documentation. Having analyzed the documentation submitted against the grounds for the proposed impeachment, I find that the documents objected to constitute evidence in support of the allegations already made in the impeachment motion as received from the National Assembly. It is noteworthy that the parties were instructed when sending responses to indicate any other evidence to be relied on. Accordingly, the documents being referred to do not constitute new evidence, but form evidence in support of an allegation which was already made. That is why Rules 6 and 7 of the Rules of Procedure permit the Senate to receive witness statements, list of witnesses to be invited by and any other evidence to buttress an allegation already made. What is not allowed is to introduce new allegations or to introduce any evidence that is extraneous to the allegations made in an impeachment motion. In the event, it is my considered view that the affidavit and document marked as Volume 8A being referred to fall within the permissible documents of our Rules of Procedure. I therefore rule that the objection is hereby dismissed. Now, honorable senators, having dispensed with the preliminary matters in this particular hearing, we will now move to hear the counsel for the National Assembly.
Mr. Speaker, sir, with your very kind permission and indulgence, we as well on the part of the National Assembly had two quick preliminary issues which we wanted to draw your attention to, Mr. Speaker, sir. They are quick housekeeping issues. If you permit me just in 2 minutes, I may be able to draw them to your attention.
Exactly 2 minutes. Most
obliged, Mr. Speaker, sir. Mr. Speaker, sir, the first one is in relation to the bundle of documents that we have filed before this House to help it determine the matter that is before it. In particular, we have one of our documents, or one of our volumes, Volume 4, as a document presented before this court, before this Honorable House. Mr. Speaker, sir, when we were perusing our documents earlier today, actually yesterday, we did realize that one of the documents in that Volume 4, running from page 135 to 140, appears to have been inadvertently copied just on one part. In other words, in the course of a printing, we missed out the even numbers and just printed out the odd numbers. Mr. Speaker, sir, we have since availed that document. It is not a new document. The only thing that had happened is that we forgot, or rather inadvertently, we didn't get the even numbers printed. We have since done that, Mr. Speaker, sir, and with your permission, we urge that we be allowed to rely on that document. We filed it, Mr. Speaker, sir, and served it to our colleagues, counsel appearing before His Excellency, the Deputy President, as well as to the House, that it may be relied upon. That is the first preliminary intervention that we seek. Mr. Speaker, sir, the second issue is in relation to a letter that we did to yourself on the 14th of October 2024, wherein we sought the help of this House through your office to have summons issued to the CEO of the Ethics and Anti-Corruption Commission for purposes of helping give testimony to matters that are before this House. Mr. Speaker, sir, the reason for us seeking this preliminary intervention is to ask formally that those summons, Mr. Speaker, sir, be issued so that the said witness could attend to help us determine the matters that are before you. We, in our letter, did indicate the specific item that is to testify to, and it is equally our humble plea that an order be made that summons do issue to have the CEO of the Ethics and Anti-Corruption Commission attend as a witness. I am most obliged, Mr. Speaker, sir.
Counsel for the Deputy President, what say you?
Mheshimiwa Speaker, honorable senators, with regard to the first request, which I understand to mean that when they were photocopying, some pages were left, we are going to examine that and see what was served on us and what those pages that are now being introduced contain. With regard to summons to ask individuals from the Anti-Corruption Commission to come and give evidence, Mheshimiwa Speaker, honorable members, we draw your attention to Article 50 of the Constitution, which is the fulcrum of a fair trial. And this honorable House is executing a quasi-judicial function of the most weighty nature regarding the removal from office of the Deputy President of the Republic of Kenya, elected by the people of Kenya. Nothing would be more prejudicial than to call witnesses whose statements or affidavits we have not seen. The whole purpose of affidavits and witness statements is to enable the other side, in this case, the Deputy President, to seek legal advice, to give instructions on how best to respond to it. And this Honorable House has fixed 2 days for this trial. And one of the issues we'll be raising is these allegations, and you are going to go through them, against the Deputy President, suspicions, conclusions, on matters that were never referred to DCI in Kiambu Road, who are trained to investigate these matters. Nothing was referred to the Anti-Corruption Commission or any of the other investigative agencies, including money laundering. We strongly object and ask that the record of this Honorable House reflects that if this is permitted for the National Assembly to call witnesses at this stage without first furnishing us with their witness statement and affidavit, the case of the Deputy President will be irredeemably prejudiced. So we object very strongly to that application.
Counsel for National Assembly.
Mr. Speaker, sir, in brief rejoinder to the objection by learned senior counsel for the Deputy President. Mr. Speaker, sir, in the invitation to attend that was extended by this House to the National Assembly, the invitation included a request as to a list of witnesses the National Assembly required summoned. We responded to that request, and Mr. Speaker, sir, all we seek is a confirmation that our response has been actioned. What the learned counsel for the Deputy President is objecting to is not our request, but really it is a response to a request made by this august House. I'm most obliged.
Counsel for Deputy President, do I get it that you have no problem with the first request made by the National Assembly?
Mheshimiwa Speaker, we would want to see those pages. And that time we'll be able to say yes or no. It is the second one.
Clerk, has that document been made available to the Deputy President's team? Kindly, in the next few seconds, make it available so that we make progress. Honorable Senators, if there's any senator who has not gotten that document, you may also let the chair know so that we supply you with that document. Senator Mazayo, Senator Olekina, Senator Miraj, Senator Kavindu, Crystal Lasige, Senator Kajwang.
Honorable Speaker, if I may, with your permission, just to highlight one point based on my learned friends for the National Assembly have said. The letter they refer to is a letter dated the 14th of October 2024, It is addressed to the Honorable Speaker of the Senate by the Clerk of the National Assembly. The letter does not contain any information about any other witnesses being sought. It does not indicate that the Ethics and Anti-Corruption Commission will be asked to produce any other witness, affidavits, or documents. Thank you very much.
Mr. Speaker, sir, if I may.
Just take your seat for a minute. Senior Counsel Paul Mwite, are you in receipt of the document now?
Mheshimiwa Speaker, this document, we are seeing it for the first time now, 3-4 minutes ago. And it has got many, many pages, so we were quickly going through it. And in order to save the time of this honorable House, perhaps you can give us an opportunity to go through these documents, because we need to go through them. Inaonekana kama hii ni ukarabati, but let's go through it. Perhaps if you agree, Mheshimiwa Speaker, perhaps we can get on with the first prosecution witness giving evidence, and as soon as we've gone through this, then we shall come back to you, Mheshimiwa Speaker.
Thank you for your wisdom, Senior Counsel. Now, the other name that has been raised is on the issue of summons to witnesses. Now, if you look at our rules of procedure, more particularly rule number 10, which provide as follows, that the Senate may, at the request of the National Assembly or the President, and in this particular matter, the Deputy President, invite or summon any person to appear and give evidence before the Senate. So the summons that have been sought are in line with the spirit of Rule 10 of our Rules of Procedure. You may attack the evidence when these particular witnesses who have been summoned, if their evidence introduces other allegations, then at that particular juncture, the legal team from the Deputy President, you may raise an issue, and I'll certainly hear you at that juncture.
Permit me, Mheshimiwa Speaker, to place it on record that the rules of this Honorable Senate must and have to be respected. But even above respecting the rules of this Honorable House, our Constitution has to be respected. Article 50, the right to a fair trial, which in terms of Article 25C, Mheshimiwa Speaker, you will remember, you are aware, that is a right that cannot be compromised in any manner. There has been no explanation why the EACC was never asked to investigate the allegations before they were tabled before the National Assembly and before a decision was taken, because the National Assembly cannot investigate criminal offenses. In fact, in implementing Chapter 6 of the Constitution, the Act of Parliament said a conviction is necessary. And now you want to reverse the will of the Kenyan people in electing the Deputy President without him being reported or the matter being investigated or him being convicted. Mheshimiwa Speaker, I plead that you reconsider your exercise of that discretion in permitting witnesses from the EACC to be called in order for the Deputy President to have a fair trial before the Senate. Thank you.
Senior Counsel Paul Mwite,
Mheshimiwa Speaker,
you're actually arguing your case. What I said, there was some invitation that was sent to both parties, and each party was requested to submit a list of witnesses. The National Assembly submitted a list of witnesses with a request under Rule 10 of our Rules Procedure for the Senate to summon. That is the request that has just been made by the National Assembly, and it is permissible and it is within our Rules of Procedure.
Mheshimiwa Speaker, you are
Senior Counsel Paul Mwite, I will refer you to Rule number 30 of our Rules of Procedure, where the ruling of the Speaker is final. So let's leave the matter there. I've made my ruling. Let's make progress, Senior Counsel.
Mheshimiwa Speaker, I agree entirely. You are the one sitting in the seat of power. Your word is final. I have said what I've said. Your rules are subject to the Constitution. I accept your ruling.
Now we'll move to the second limb of this hearing. Honorable Clerk, you may now proceed to call the next order. Summons to issue to those witnesses.
Order number 2, hearing and determination on the proposed removal from office by impeachment of His Excellency Rigathi Gachagua, EGH, Deputy President of the Republic of Kenya.
Now, honorable senators, ladies and gentlemen, we are going to move to the opening statements. Each party will have exactly half an hour to make their opening statement, starting with the counsel for the National Assembly. Your time starts running from now.
Thank you very much, Mr. Speaker and honorable members of the Senate. Indeed, speaking for us, this is a very momentous occasion in our history. and must be recorded as such. The United States of America is 248 years old since its independence, and for that entire 2.5 centuries, no Vice President of the United States has undergone a process of removal by way of impeachment. In a way, we are making history. And for me, it is such an important occasion for the 13th Parliament and this Senate that it will go down in the annals of history that the first impeachment of a deputy president in the Republic of Kenya was undertaken by this particular Senate. And we come here with a lot of confidence that the Senate is not new to the process of impeachment as understood under our Constitution. Indeed, the Senate has handled so many impeachment proceedings in relation to the offices of governors and deputy governors. And more importantly, that this Senate has been a great contributor in establishing the jurisprudence revolving around the impeachment process in the Republic of Kenya. Many of the cases that have gone for determination in our system of courts, High Court, Court of Appeal, and the Supreme Court have involved the participation of the Senate. So as we address you today, we are not addressing a chamber that is dealing with a novel idea. Indeed, by dint of Article 10 of the Constitution, which requires all state organs and state officers to make any decisions or apply the law and the Constitution, they are required to apply the Constitution of the Republic of Kenya. That is by dint of Article.
Please say the volume you're reading.
I'm reading from volume 7 in our bundle of documents.
Good. Now we'll come to it. Let's go back to your allegation.
Is correct.
Will lead the witness in respect of the other grounds in the motion.
May the witness take the oath.
I, Mwengi Mutuse, do solemnly swear that the evidence that I shall give before the Senate in respect of the matters before the Senate shall be the truth, the whole truth, and nothing but the truth. So help me God.
Your 3 hours starts running from now.
So, good afternoon, sir. Again, just for the record, confirm your name and what you do for a living.
Mr. Speaker, honorable senators, my name is Mwengi Mutuse. I'm the member of parliament for Kibwezi West constituency, and I was the mover of the instant motion that is before your consideration in the National Assembly. I am also an advocate of the High Court of Kenya by profession.
So, great. Let's go straight to the motion due to the constraints of time. Honorable Speaker, the motion is in volume 1 of the Assembly's bundle of documents. And allegation number 1 runs from pages 3 to 10 of volume 1. So, without much ado, Honorable Mutuse, let's go to allegation number 1 of your impeachment motion. Can you tell the Senate in very condensed summary?
And basically, President, in the last 2 years, the president being able to promote national unity and the country, citizens of Kenya being able to receive services and development from the government, including appointments, without discrimination. So that is in short.
Let's quickly go through some of those provisions. If you could be shown the preamble to our constitution, what does the third paragraph say?